We appreciate all of you for coming. And before we start, please may I refer you to the program you have. On page 5, you see the agenda we're going to follow. Number 1 is off. Number 2, we are here the open segment. Before we go into the introduction of the special guests and speakers and the remarks by the people speaking, may I call on Father Jude Isiguzo for a short open prayer, please.
In the name of the Father, and of the Son, and of the Holy Spirit. The Lord, be praying. Loving Savior, we have gathered today for this important workshop. We ask you to inspire us, inspire the speakers, grant that it will be a successful workshop, that we continue to learn and put that into practice to the glory of your name. This we ask through Christ our Lord. In the name of the Father, and of the Son, and of the Holy Spirit.
Please, the national anthem, please. May we still be upstanding.
Nigeria's commandment to serve our fatherland with love and strength and faith. The labor of our heroes was joy morning declared to serve with heart and voice. One nation bound in freedom, peace and unity.
May I, with respect, mention and recognize it is a little bit special this time around that the Attorney General and Commissioner for Justice in Enugu State, who is supposed to represent the government of the state, is hereby represented by Ipachuku Ezewakwa, the Director of Civil Litigation. We are still expecting Attorney General, who is coming in from the Supreme Court. We respectfully ask that he be excused, that he will join us and the event moves on. You're welcome. May I, with respect, recognize the Chief Judge of Enugu State, ably represented by Honorable Justice A.O. Onovo. My Lord, you're welcome. Please put your hands together, please. So, recognize Justice C.I. Obodo. My Lord, you're welcome. May I also recognize Honorable Justice H.O. Eya. My Lord, you're welcome. May I also recognize Honorable Justice C.D.C. Ezogo. My Lord, you're welcome. Joining us online is our amiable president of the Nigerian Bar Association, YC Michael SMOON. Thank you, my president, for joining us. Put your hands together, please. May I also recognize all the magistrates who are present. Oh, sorry, please. May I recognize Honorable Justice Ajoko. Please put your hands together, please. Sorry, I didn't see that. My Lord, I'm sorry I didn't see that. Thank you very much. May I also, with respect, recognize the chairman of the NBA on a labor practice ABL committee, Isaiah Bosno SN. Put our hands together, please. May I also, with respect, recognize first female senior advocate east of the Niger, an amiable, loving, caring, Iyom Aging Ofia SAN, fellow Chartered Institute of Arbitrators. You're welcome, ma. Welcome. May I, with respect, recognize Ikechukwu Onome SAN. Billionaire Sector, welcome. May I recognize the chairman of the bar, CNN Wabba. The chair, you are welcome. Please, I don't know whether is it hunger that you are not clapping or what. Please put your hands together. It is a common thing that if you celebrate someone, you will be celebrated. Please, let's make it lively as we sit down to learn. Thank you so much. May I recognize here seated Mrs. Margaret Mabo, fellow. Thank you, thank you, thank you. Welcome. He's the chairman of the District Resolution Committee of the NBA. Thank you. May I recognize our own Mrs. Carol Etok, the Director, Multi-Day Courthouse, Enugu State. Please put your hands together, please. May I recognize our special guest, Actionable, Acting Director, Lagos Multi-Day Courthouse, Director of Civil Litigation. Please put your hands together. All the way from Lagos. May I recognize our own Reverend Father Jude Isiguzo, the Executive Director, Capo. Please, you are welcome. As we go on, please, we'll that our own president, YC Mekao SN, is with us online. Our amiable president, YC Mekao SN. Please put your hands together. Put your hands together for one. My presidents are welcome. Thank you so much. The recognition will continue as the function proceeds. My plea is that you relax and follow the events as it unfolds. With respect, may I invite our president, Nigerian Bar Association, YC Mekao OON for his brief remarks. Thank you.
Thank you very much, Jude. May I respectfully adopt the protocols already established by my good friend and brother Jude, that is organized by the section of legal practice under the able and sagacious leadership of my learned brother Silk, Omar Alabi, who is OON, and which stands for the owner of Nigeria. I'm privileged to be a co-owner of Nigeria along with her. I want to first and foremost appreciate the learned brother Silk for the leadership she brings in the section of legal practice and the support that the Nigerian Bar Association is enjoying through the work of the section of legal practice. I would like to also appreciate my good friend, Isaiah Bozimo, Senior Advocate of Nigeria, who is one of the faculties at this workshop. Just for the purposes of the record, Isaiah Bozimo is my mentor in ADR, and I know that it's not a coincidence that he's one of those to share his knowledge and experience in the practice of ADR at this workshop. We're lucky to have him be part of this workshop. Let me just say that in our drive as Nigerian Bar Association to create more opportunities and prosperity for our colleagues, one of the areas where we believe we can make this possible and achieve this objective is in directing our colleagues to the practice of ADR. That is why I consider this workshop apt and timely. And I want again to commend the thoughtfulness, the purposefulness, and foresightedness of the leadership of the section of legal practice in putting together this workshop. I would have been there live myself, but because I have to attend the special court session in honor of our past president, Arakunri Akeredolu, Senior Advocate of Nigeria, who passed on the 26th of December last year in Ibadan today. The special court session just finished, and I now became free to join virtually, but I would have been there in person to participate in this workshop, not the least because of the quality of the faculty put together to share their knowledge and experience in ADR. You know, I see the name, and of course I've seen the picture of my sister Caroline Etuk, one of the foremost mediators that we have in this country, come to share her wealth of experience in the great works that she did in the Lagos multi-door house and then setting up the Enugu multi-door courthouse. This is an experience that I know we would not forget, not even in a hurry, not at all, because it's something that will continue to savour, it's something that will continue to benefit from, and it's going to improve the lot of our practice, it's going to improve on our prosperity. And so I would like to request all those that are privileged to be a part of this program to pay attention to what you will learn, the techniques of mediation, and how to prepare for mediation, court-ordered mediation. I think that is a process that is fast gaining ground in our courts, in our practice, and it's something that I believe the understanding of which is going to help us do better as we help in not only decongesting the dockets of the courts, but also decongesting that basket of unemployment and lack of fruitfulness in our practice. I mean to say that if we give attention to ADR, what we used to hear about the lack of, let me use the straight word, money in ADR, in mediation, it's not true. It's not true. I mean, those of us who, we were not deceived, but we were more attracted into litigation. We go to court, you know, we think wearing the gown and standing and doing our matters in court is what would guarantee the prosperity as a legal practitioner. But we've come to realize that that is not the case. Those you don't see in court often are the ones who are really making the money. And now you can see how mediation has come to be part of what we do in court in litigation. In some jurisdictions, before you even file any action in court, you are required mandatorily to go to mediation. And that is how those jurisdictions have realized the speedy dispensation of cases that should have been dispensed with in a short period of time, that would have to stay for a long time in court, you know, have been disposed of by reason of the application of the techniques of ADR, particularly mediation. So I like to I thank the organizers again and commend this program to each and every one of us. And I would plead with SLP to do this program again and again in all the jurisdictions, bring it very close or closer to our colleagues, so that as we equip our colleagues with the techniques of mediation, we would see a tremendous improvement in the way matters are disposed of in our courts. And I must commend the Enugu State Judiciary. The turn-up of judges and magistrates at this workshop is also an indication that the courts have embraced ADR, which is obvious. I mean, in the rules of court, we see the endorsement of ADR, and also in practice, we see how the courts have been referring matters to the multi-door courts, that is the jurisdictions where the multi-door courthouses have been established. Achere Cole brings a wealth of experience, you know, as acting director of Lagos Multi-Door Court. I mean, we can't be luckier. We can't be luckier than having this faculty to deal with these particular issues. And like I said, my mentor is there. He always points me to the things that I need to do. So much effort was put in place in bringing about the enactment of the Arbitration and Mediation Act 2023 that recognized the Singapore Convention on Mediation. I know that in the course of this workshop, there will be a mention of that as well. And some very interesting cases are happening across other jurisdictions. I recall that in November last year, I was privileged to attend the proceedings of the Court of Appeal in England, presided by the Chief Justice of England and Wales, with the Master of Rolls on the panel, and one other Justice of the Court of Appeal, talking about mandatory referral or reference or referral to arbitration, referring parties to arbitration, whether that impairs on the fundamental rights of the parties, talking about the European Charter on Human Rights, whether that contradicts it. So there are interesting issues. What I'm saying is that with the techniques of ADR on your fingertips, you are good to go with respect to your practice nationally and internationally. So I want to commend again the organizers of this program. Please do not leave any of the faculty members with their intellect and knowledge to go out of that place without squeezing them literally dry. They've got enough of knowledge, information that we take from them. Let us make the most of this opportunity. The Nigerian Bar Association supports this program, and we will ensure that we keep doing what we need to do to properly equip our colleagues for the purpose of the prosperity that we are all desiring to see and to have. So I thank you so very much for the opportunity to speak and make a few remarks in this respect. I wish you a wonderful moment. I know you are in for a great and serious intellectual treat in the business of mediation. Thank you very much. God bless you all.
Please put your hands together very well for our president. Thank you, our president, for the comments. Before we invite our own chairman of the session, please permit me to respectfully recognize our chairman, because I understand that he has been online. Our own chairman, Boma Alade, MSAN, chairman, MBA section on legal practice. Please put your hands together. You're welcome, please. I also recognize one of our friends here, Chief SBC Oboko. Thank you so much. I want to use this opportunity to appreciate the section on legal practice for bringing this workshop to Enugu, and Ike Onoma for his good work. And this kind of workshop is not easy to put together. So we appreciate the section for choosing Enugu for this. It's a very big benefit for the lawyers here, and we appreciate you so much.
I am grateful to the chair and members of the ADR subcommittee, ably led by my learned brother Silk Isaiah Bozimo, SAN, for kicking off the first of our SLP workshops for the year 2024, and actually starting in Enugu. Because one of the things we want to do as SLP is to ensure that we get to every part of the country. We have practitioners across Nigeria, not just in Lagos, Abuja, and Port Harcourt. We're grateful to the Enugu State Judiciary, to the Enugu State Attorney General and government for hosting this first meeting. I thank you all very much. I'm looking forward to learning, interacting, and really getting a lot out of this afternoon. I'm most grateful for the opportunity to be with you, albeit virtually. I'm going to keep it brief because of the quality of the network. I thank you very much indeed. Good afternoon.
Put our hands together for the learner Silk. I think I was sitting very close to the chairman of the ADR section and sleep, and I had the heartbeat. That's what the chairman of the session legal practice meant by saying in court was an ADR session. Thank you so much. Please, may I recognize Honorable Justice Ngozi Oji. Please, you're welcome. Thank you so much. Thank you for coming. So, may I with respect invite for his comments the Attorney General and Commissioner for Justice in Enugu State, ably represented in this function by Ikechukwu Ezewuka, Director of Civil Litigation. Thank you so much. The Chief Judge of Enugu State, ably represented by Justice A.O. Onivo. The other judges of the Enugu State Judiciary, the magistrates, the members of the ELA and the outer board, the chairman of this session, the chairman of different branches, the Enugu State, ladies and gentlemen, good afternoon. This is an address presented on behalf of the Honorable Attorney General of the Commissioner for Justice, Enugu State, Dr. Kingsley Tochi Ude. I bring back details from the Honorable Attorney General of the Commissioner for Justice, Enugu State, to this very important workshop tagged Actionable Strategies for Mediation after court referrals by this committee, as a committee in the state. No doubt that the choice of this topic is apt at this time. Knowing that alternative dispute resolution is the emerging trend in justice development the world today. The goals of the nation cannot be overemphasized. Its numerous benefits, which includes giving parties more control over the process and its results. Effectiveness in respect of time, flexibility and cost effectiveness as against litigation. We cannot be left out of this moving trend in view of the growing social and economic realities of our time. Effective and efficient alternative dispute resolution strategy. In order to start we are learning these facts. And quickly embrace mediation as one of the very conditions to enhance access to justice and effective justice delivery in the state. The state has undergone, among others, the establishment of a courthouse to effectively dispute justice, either as a weapon centers by our courts. We are on the Citizens' Right and Mediation Center at the Ministry of Justice. Also, training for those legal officers and judges in the Nba-Slp judiciary and enhance the litigation skills to ensure a successful outcome of prosecutions referrals. Some conditions are made. There are several available states, 7 available states, 2020. Referrals to the municipal courthouse and the process of adopting the resolutions as judgment of the court. The state governments, in its concerted efforts to ensure the success of mediation as a tool for effective justice delivery, made mediation one of the commitments of the mandates of the to ensure effective mediation process. To this end, the Ministry of Justice has taken steps in appropriate cases to settle most disputes on mediation and further improve the capacity of its staff through training to ensure better service delivery. We hope that our people will take advantage of these various opportunities the state government have provided for its citizens for get a quicker and effective justice in the state. This desire has propelled the state government to quickly accede to this continuous request to partner in this workshop by collaborating with your esteemed committee and the Nba-Slp judiciary. We urge our continuous partnership with you, and we wish all our participants a fruitful celebration and urge you to take the benefit of the hospitality of the great people of Enugu State. Thank you and God bless you. Thank you, Honorable Attorney General. Please, may we give him another round of applause, please. Thank you very much. In Enugu State, it is very obvious for all litigation lawyers, people who are constant in court, to know that our judges and our magistrates are ADR inclined. That is one of the advantages we have in Enugu State. They are full of energy. Their interest is robust about settlement of disputes in another alternative way than pure litigation in court. That is why we appreciate them so much. Please put our hands together for our judges and magistrates. I will say, may God bless you. We thank you so much for your good work and your insistence that disputes must be settled outside the courts, except when it becomes almost impossible. Thank you so much. And that will lead me to invite our own Chief Judge of the state, Honorable Justice A.R. Ozomana, represented ably by our own Honorable Justice Oliver, for his own comments and declaring this workshop open, my Lord.
His Excellency, here ably represented by the Director of Civil Litigation, Mr. Ezemukwa. My brother judges of the realm, the learned magistrates who are here present, the Director of the Enugu State Multi-Door Courthouse, Mrs. Carol Etuk, the Acting Director, Lagos Multi-Door Courthouse, Chairman MBA, Enugu Branch, CNN Wabara, Reverend Father Jude Isiguzo, the Executive Director of Capio, Mrs. Margaret Nwabu, Chairman, Dispute Resolution Committee of NBA, the members of the inner and outer bar, ladies and gentlemen, I'm here to represent the Honorable Chief Judge of Enugu State, who is unavoidably absent. His Lordship would have loved to be here, and he had planned to be here. But the exigencies of office have taken him out. So I apologize on his behalf. He said I should represent him at this function. So I commend the section on legal practice of the NBA for bringing this workshop to Enugu State. So on behalf of the Chief Judge and the Committee of Honorable Judges of Enugu State, I welcome each and every one of you to this workshop. And for those who are coming from outside, I welcome you to Enugu State. I'm quite sure that it is a recognition of the growing influence of ADR in the practice of law and the resolution of disputes that Enugu State was in the forefront for the establishment of a court-attached multi-door courthouse. And the Honorable Attorney General has stated the fact that an edifice has been erected. They earlier started from these premises, but they now have a compound of their own with state-of-the-art edifice befitting of a court-attached multi-door courthouse. I think the government of Enugu State and the Enugu State Judiciary are proud of the multi-door which they have established, and the good citizens of Enugu State are making proper use of that multi-door courthouse. It may not be up to what is expected, but at the beginning, some people were quite skeptical. Some lawyers didn't want to key in. But I will encourage all legal practitioners who have not keyed into the project to get used to it, because that is the legal practice of the future. This workshop on court-ordered mediation has the topic Actionable Strategies for Mediation After Court Referrals. We will listen to presenters, we'll have discussions, and we'll go out of here better enriched than the way we came in. So I call on all lawyers who are yet to get used to this practice of the future, to get into the project and participate effectively so that all of us will be better for it. My attention has been called to the fact that our own EOM and the first female SN in the Southeast is here. I greeted him when he came in. Iyom AJ Ofia SN. A young man met me when I was coming in, and when he introduced himself, I asked him, "You are the Oga for today?" He said, "No, no, 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 I'm not the Oga. But I've already mentioned in the protocol is he ranks among the Ogas at the top. Isaiah Bozimo, SN, who is the chairman of Nba-Slp, the ADR committee. Our own Ikechukwu Onoma SN is also here. Chief KC Olemo for NBA chairman, Oji River branch. These people are pivotal to the event taking place today. So, ladies and gentlemen, I wish on behalf of the Chief Judge of Enugu State, Honorable Justice A.R. Ozemena, to declare this workshop open. Thank you.
Thank you so much, my Lord. My Lord has discharged his functions so creditably. Lord, we thank you so much. We appreciate you. Please, we must move into almost about 15 minutes behind schedule. But I want to inform the non-lawyers that are here, non-lawyers, that there is an item 7. So you have to sit down and open your ears, but there will be question and answer before that section will take place. Thank you very much. If you look at page 5 of your program, please. Page 5. I don't like people putting program inside their handbag. Bring it out. Page 5 of the program. In the second segment, and that second segment is the workshop proper. It will be divided into 4 focused interactive discussions. And that's one of the things that makes me appreciate the organizers of this program for making it interactive. That is where the knowledge will sink inside. I'm very happy. So may God bless you and our children as I do SN. Thank you so much. May I invite to the place of discussion. His name is Bodham. Our own chairman of the committee, ADR session legal practice, Isaiah Bozimo SN. Put your hands together for a year. Active and reliable. Thank you, SN. Thank you. Thank you. We also invite our own silent achiever, the man I love so much, one of the newest Yaraba SN, East of Niger, my beloved brother, SN. Put your hands together. And OON in the. So we're going to break it down into 4 segments. You can see it up here. Segment 1 would be addressing some of the concerns we think are preventing lawyers from embracing mediation. If that lawyer that was doing the case for Mama's goats did mediation, Mama would have her goat. So what are some of these concerns? And why is it important? Again, well, I had the distinct privilege of serving as Attorney General for Delta State. And one of the things we did in civil justice reform, criminal justice as well, but for the purpose of this discussion, civil justice reform is we wanted to know the rate at which cases were being filed and disposed. And for the year we took that data, we found that year on year, there was a net increase That is to say, more cases were being filed than more cases being resolved. Now, put that against another data point. The number of cases settled during settlement week, quite high. So it gets you thinking that why don't we treat every week as settlement week? Why are we focusing on one particular week to say, okay, mediation is very successful during settlement week, but all other times we continue as if ADR doesn't exist? So there must be something driving the desire that is pushing lawyers to litigate rather than choose alternative dispute resolution. And one common denominator that I have found is money. Somebody told me that money matters matter. Abi? It matters to you? Yes, my friend is smiling at the back. It matters to him. So let's start a discussion. Is there a perception that ADR yields less revenue than litigation? If you think so, don't be shy, please. It told me that lawyers in Enugu are not shy, that you are ready for a discussion. So do you think, is there a perception that I will get more money from litigation than I would, for instance, mediation? Do you think so? What do you think? You've been looking at me. What do you think? You can nod or you can shake your head. Which one? What do you think? Yeah, okay, DCL is nodding. Yes, sir, please. Thank you.
Mr. Chairman, honestly, frankly speaking, many lawyers, not only in Enugu, who have not embraced ADR, we say that ADR simply means acute drop in revenue. It takes time during workshop like this, seminars, conferences, to begin to convince them that really, in actual sense, in the modern world, that we make more money. Like in one of the conferences we have in Lagos, Professor Ajogu, when he was telling us the amount we made in one settlement he made, everybody marveled. You see that you have been wasting your time making things one case for 3 years, and then they pay them, so that someone can make dollars in other one. So that is very important. That settlement is being gradually changing because of this case workshop and I'm going to take care of it.
Thank you very much. Thank you very much. And that's a story I hear in very many jurisdictions. The perception that ADR equates to alarming drop in revenue. And so I then ask, I will give you my example as to how I think we are having that perception and why I think it's wrong. I think it's not a problem necessarily with ADR or with litigation. I think it's more to do with the way we as lawyers engage with clients when it comes to fee. We are not taught how to be business people in law school. We are taught how to practice law. But the reality is, you probably have an office you are running, you are paying rent, or you've bought a building, you are paying your lawyers. So at the end of the day, you are actually running a business. And so I will ask a lawyer, for instance, well, how much does it cost you per year to run your business? So how much do you need to break even? And they were like, I haven't thought of that. Okay. How do you approach issues of billing your clients? And then it becomes very uncomfortable. We don't like having that conversation about money. But let me share my experience as to how I do it, and perhaps get 1 or 2 experiences which I think will work. We are very privileged in the sense that when a client comes to us, number one, we know that they have a problem. Particularly if you're a litigation lawyer. If you're a litigation lawyer and a client comes to you, that client has a problem. It's not, transactional lawyers, they do very important work, but they're actually trying to prevent disputes. It's, put it this way, it's like when you see your doctor once in a while, and your doctor says, oh, do this, do this, do this, it will prevent illness, preventative medicine. By the time you go to see a litigation lawyer, you are sick. We must operate on you. Things have gone bad. So that means your client wants to get from destination A, the point of pain, to destination B, the desired outcome. And getting from A to B is a transformation. Just remember that. I'll come back to that. Now, typically when a client comes to a lawyer and says, this is my problem, most lawyers I've spoken to, and I'm hoping Enugu will be the exception, but most lawyers I've spoken to are already thinking about litigation straight away. Okay, right, I can file an injunction, it will prevent this, I can then bring an action. We're thinking litigation already. It's our default mechanism. I haven't even started thinking about what solution I'm going to offer you yet until I know the extent of your problem. Why do you think that is? Why do I want to know the extent of your problem? What do you think? Did somebody say something? Please, don't be shy. Ike, you said they're not shy in this town. What do you think that is? Okay, I'll tell you. The bigger your problem is, the more you want a solution for that problem. The bigger your problem is, the more money you will be willing to pay for a solution. And why do I say this? There was a client that came to me and says, oh, I have a very small problem. And when they say you have a small problem, alarm bells should be ringing. Okay, what's the problem? I entered this contract and the other side is threatening to terminate. I haven't done anything wrong. I need something like just an injunction or something to stop them. Okay, tell me, I haven't given him any solution yet. Tell me the nature of this business. Oh, it's just one small business like that, and it was in Cross River State. Okay, what are you doing? We are supplying power to a particular area. How big is the area? Oh, it was actually Tinapa Business Resort in the end. Small problem. Okay, you're supplying power. Do you mean you are providing diesel for a generator? Well, no, we have a power plant. Okay. What's your take or pay rate? So take or pay is if you do power purchase agreements, you know how much the taker must pay each month, stated the amount. So this small dispute that you have told me about, how much is it costing you on a daily basis? And that's where the real value now came up. So in a year, the small dispute will cost that business 5 billion naira. Small problem? No, big problem. All right, so no solution yet. Okay, what's your ideal outcome here? What are you looking to get? Why do you think you need to go to court? I need an injunction. Yeah, but what's your ultimately, what do you want to happen? Do you want to exit this business? Do you want to continue this business? How much will it cost you to exit this business? How much will it cost you to continue? We went through all that. And ultimately, I then discovered that this person wants to continue the business. It's a lucrative business. 5 billion naira a year is not small money. Now, think about it like this. If you said, let's go to court, and if you told your client up front, oh, sorry, before I get there, let me tell you how we then priced it. So I said, okay, essentially you have a 5 billion naira problem on your hands. And they said, yes, we have a 5 billion naira problem. What do you think is a reasonable amount to solve this problem? They thought about it. I said, no, it's a business problem. If you were going to throw a business solution at it, how much would you spend to resolve this business problem? So I haven't really thought about it. They're evading your question. Don't let them go. Okay, would 10% of that amount be reasonable in your estimation to solve that problem? So in other words, you're throwing 500 million naira to solve a 5 billion naira problem. They said, yeah, 5% seems reasonable. I said, okay, here's the good news. I think I know what your problem is. I think I know what the solution could be. And I know that it will cost you a lot less than 10% of 500 billion. So if I was to come to you with this solution and it will cost you 0.1% of that amount, is this something you would be willing to go along with? They thought about it, put the maths, they say, yes, it's not a problem. I'll leave you to do the maths of 0.1% of 5 billion. It's 50 million. So all of a sudden, I've gotten the client to commit to say, the solution you will offer, I am willing to pay 50 million naira for. And I haven't even said, I'm going to court or I'm going to this place. Now, the process of doing that is to understand that when a client comes to you for a problem, they want you to provide a solution. What you have to realize is how to value the solution. The value of the solution is the transformation that client will receive. So let's go back to this example. If, for instance, I told the client, okay, yeah, we can file an injunction, we can stop them from breaching the contract. Maybe in the high court, if you're in a busy jurisdiction, it might take, I don't know, 2 years. It might take us 2 years, we'll finish the high court matter. It's contentious, so there's a lot of money, they might appeal. If we go on appeal, maybe we'll spend 3-4 years in the court of appeal, right? Then there's one more stage, go to the Supreme Court. Supreme Court is quite busy at the moment. Maybe we'll spend another 5 years there. And I want you to pay me X amount of money. Client will think about it and say, the money I am paying you versus the transformation I am receiving, I don't value it at that amount. I'm not prepared as a business to spend up to 8 years going through all levels of courts. There might be a situation where the client is comfortable with that. If they want to set a particular precedent, they might be comfortable doing that. But if it's a business transaction, it is unlikely. So if you now say, okay, Oga, pay me 50 million naira and spend 10 years in court, they'll look at you and say, you're mad. Because I don't value the outcome at 50 million naira. But if you say, okay, let me attempt to mediate this for you. This is my track record. I've done 10, 15, 20 mediations, and this is the outcome I have achieved. And I think if we take this approach, there is a high likelihood that we can get a solution in 6 months. All of a sudden, the businessman is now thinking, that value I am receiving for your service is worth me paying that amount of money. In other words, our relationship, we have to think of money now in a completely different way. You have to think of money as measuring the value of what you are offering your client. Thank you very much. So you think of money in a way of measuring the value that your client is receiving. So that way, whether it's litigation, whether it's mediation, ADR, your client is the one that is driving the value of this process. And I can tell you that practicing, I'm a dispute resolution lawyer. I've been doing that since I was called to the bar. I was called in 2006. I took silk last year because somebody was saying, you might just be saying all this because you're a senior advocate. You have made all the money you want to make. No, I've been a senior advocate for less than 1 year. But I've been doing this since my call to bar and since I left my mentor, Patrick Ikweto, Senior Advocate of Nigeria, in 2017. In fact, this case I've told you about for this power dispute was my first ADR case after I left Ikweto. They didn't pay me 50 million. because they thought I was too young. But we had a conversation in a way that the fee I charged, the client felt that I'm getting value. I'm getting value for this, so I don't mind paying it. And we didn't go to litigation. We solved it in about 9 months. And that client is now referring more work to me. Go back to this person, go back to this person, because they've seen that you have a proven process that yields a given outcome. The outcome your client wants is what you should focus on, rather than the outcome you think is right for them. So get into the practice of having that conversation. So I know there are 3 more areas to discuss. So let's move on to the second part. If you have any questions, please just note them. Note them, and hopefully we'll have time to interact later and develop more of these ideas. Doctor, I know Doctor has a point of view, but we'll take that at a later stage. So thank you very much for listening. And let me, at this stage, pass it on to, you're taking the first second. Yes, let me pass it on to the director of the Enugu Multi-Door Courthouse, a lady who I've admired for many years. I've had an opportunity to work with her when she was in the Lagos Multi-Door Courthouse and in other fora. So please take advantage of her. She is a wonderful and eminently qualified person. Thank you very much.
I'll just make some progress because of time. And well, I guess I would observe all protocols. The Honorable Chief Judge of Enugu State, represented by Justice Onowu, that's an insider in the Multi-Door Courthouse. I'm going to blow your cover, my lord. He's been the chairman of the Enugu State Settlement Week for many years. My lords, and all the friends of the Enugu State Multi-Door Courthouse. Now, well, we have 3 segments left. I'm going to take the first segment. Mrs. Cole, the acting director of the Lagos Multi-Door Courthouse, is going to talk about mediation proper, the process and procedures, and then I would finish up the presentation. And I'll try and make it as interactive as possibly can. I also do wish that we had many more lawyers in the room today. I don't know whether the absence of lawyers has to do with today being a Monday. Okay, it's hybrid, so we have a lot of people online. Okay. Now, the first question I like to ask is, why should a lawyer be concerned about alternative dispute resolution? Now, the answer to this question has been addressed today over and over, and I think basically it has been overflogged. Is there any lawyer in this room that believes sincerely that alternative dispute resolution is not a needed process in our legal system? Is there anybody? If there's any such person, I would ask you to raise up your hand and really explain why you think so. Now, because ADR is making waves all over the world, and lawyers, starting from the law school, I know there's some training going on in the law schools, but they are grossly inadequate. But I know all over the world, in practically every university, you're having lawyers have a full-fledged training on alternative dispute resolution to get them as prepared for the industry as they are when it comes to courtroom advocacy. So I'd say, in a manner of speaking, that a lawyer in the 21st century that does not have alternative dispute resolution skills, whether it be arbitration, mediation, or any other skills, is a lawyer that is not fully balanced, is not fully equipped for today's dispute resolution market. So professionally, every lawyer should actually seek out to build capacity and expand your area of intervention, expand your value, as it were. Now, there are 21 multi-door courthouses. I was asking Mrs. Cole today if she knows if anybody else has joined the ranks. In Nigeria, there are 21 multi-door courthouses, and each and every one of them is referring cases to alternative dispute resolution. Now, I know for so long, Lagos Multi-Door started in 2002. That's when the multi-door courthouse kicked off in Lagos. And I know that there had been, over the years, a lot of pushback from lawyers. Lawyers did not understand why, this matter of our revenue and this process coming to take off from our revenue and all those sort of issues were really a problem. But today I will say there's a significant change in the field. So what are you expected to do? A 21st century lawyer is expected to be a mediation advocate, which simply means you need to have the skills to represent your client in mediation. And you have to do that confidently. Now, for a mediator, it's easy to determine when a lawyer is ill at ease in mediation. You have different types of reactions. You have outright resistance, and the lawyer tells you, mediator, I'm just here out of respect for the court. My client, not me, it's always said my client has absolutely no interest in resolving this dispute through mediation. For others, they just take a back seat and fold their hands, and on occasion, some lawyers have slept off while mediation is going on, leaving their clients in the high seas to navigate the terrain on their own. And I guess they still expect to be paid at the end of the day. So this appeal I've made hundreds of times, that lawyers need to step up, embrace ADR, make money from it, and learn. Now, when your case is referred to the multi-door courthouse, there are a lot of objections we hear. This case is not suitable for mediation, is one of them. This case is not suitable. Now you ask the lawyer, why do you feel the case is not suitable for mediation? The parties are not very happy with the process. So what do you know that the process entails? Is it not the same thing in other ways you do with the umonas? Is it because you have been required to come to the multi-door courthouse to sit around the table with an experienced mediator? Explain to me what is the real problem. And more often than not, they don't have anything to say. Now, some say the case is not ripe for mediation. We really don't know what all the facts are yet. That might be a valid reason, because to engage in mediation, you actually need to know as a lawyer what the full ramifications of your matter is, and much more. Some say my client does not want to come to mediation. My client is not interested. We want this case to be litigated. We want the court to give a judgment of this case. We want to see the end of this matter, so that all the village people will understand that is the Okonkwo family that owns this parcellated land, this land that has been parcellated into 250 plots belongs to the Okonkwo family and no other family. So we need a court vindication on the matter. That really still is not an excuse to exploring mediation. Now, typically what happens, and I'm sure, how many of you have had the experience of having your matters referred from court? Please, can I see with a show of hands? How many of you have had your matters referred from court? Please lift up your hands quite high. Okay, you don't seem too many. I was asking a magistrate this morning, she wants to do some training, and I was asking her, Your Worship, how many matters have you referred from to the multi-door courthouse? And she says, 1. I almost said, Your Worship, I'm not going to train you to be a mediator. So we are using a lot of arm squeezing and blackmailing now to make sure that we get cases. Now, typically, everything would start with a court referral. I'm not going to go now. The magistrate's reason for not making many referrals is that the lawyers are insisting that they must have their day in court. That's her reason. Now, the magistrate court laws have not yet been worked on, but if you come to the High Court, the rules of the High Court give the judges the discretion to refer matters. That means whether a matter is referred or not is left with the judge to review the case, check the parameters of the matter, decide if this case is good enough for mediation, and then refer. But we require judges and magistrates to really be activists, really take their stand with respect to referring. I told the magistrate, you can persuade the parties if you don't feel that you have the right or the mandate to make a referral. You can persuade the parties. You can show them all the options available. We have some judges that if you take your matter to multi-door courthouse and you return without having done your best at mediation, giving a good faith attempt at mediation, you know what? The judge sends you back to the multi-door courthouse. So collectively, if we have to grow a system that takes root and we are sure that this is going to help both parties, counsel, the multi-door courthouse program, and the judiciary, then there needs to be much more interest. There needs to be much more push from everybody concerned. So your matter starts with a court referral. We've had a challenge in respect of this. The courts refer matter, and the applicant does nothing to ensure that the multi-door courthouse is seized of that fact. So we've had cases in which a case has remained in the court docket for like 2 to 3 months, and nobody has come to the multi-door courthouse to say, okay, this is a referral, so that we kick our own process into action. Now, what we have done with respect to the magistracy is that we now have a help desk at the magistrate court, which harbors, we know, Enugu South and all the magistrate courts in the Enugu metropolis. We have a help desk there. So now it's easy because the court clerks can just carry the referrals to the help desk and we take over from there. But if your matter is filed in the High Court, please make an effort to just pick up that referral order, bring it to the multi-door courthouse, or simply notify us that this is what has been done and we will take over from there. Now, the next thing you need to do, of course, is to be at the multi-door courthouse and file your processes. For court-referred matters, we don't require you to do anything else. Just bring us copies of the court's pleadings, the pleadings which you filed in court. When this is done, usually we'll call up the respondent and say, we have this matter, it's court referred, and we want you to engage. Mediators are appointed. So far, we don't have parties requesting that mediators that they need this mediator in very few cases. They say, oh, Mrs. Etu would like you to mediate this matter, or Mrs. Achebe would like you to mediate this matter. Now, we'd like to see more of that. We'd like you to see more of that, because we know that once you experience the style of a mediator, and that style suits your own style and expectations from a mediation, then you can request to have a particular mediator appointed in your case. Now, in terms of self-preparation, I'll just do that very quickly. How do you prepare? Nobody here I know stumbles into court with a case file, or maybe you do. But for mediation, there's a lot of preparation needed. If I'm a lawyer, would it make sense for me to represent my client in mediation without any idea of what the process entails? So it's important to understand the mediation process, understand what it's about, what are the objectives of the mediation process, and what is my role? Is my role in the mediation to sit and watch the mediator and the parties struggle through the process? What do I have to add? What is the value that I, as counsel, bring to the mediation table? Many people complain that the multi-door courthouse mediators say the lawyers should not attend mediation. I don't think that is absolutely true. It's important for lawyers, especially in court-referred matters, be at the mediation, participate in the mediation, which Mrs. Cole is going to take us through in much detail. Participate in the mediation, learn the process of the facilitation, and add value to it. Now you need to know your client's wider affairs. She has a scenario that has to do with a property sale. What is your client's real interest? Now, we are not talking about legal facts here. What is your client's real interest? That is the bedrock of mediation. The mediator is going to excavate the process to find out, what do these people really want? Because the truth is that more often than not, the pleadings you lawyers prepare are pleadings meant to help you win the case, not to help you get for the client what the client really wants out of that dispute. Now, there's a whole lot a mediator has to do. You have to understand the entire case. You have to understand what it is that my client needs. When my client gets value out of this mediation, what would that value likely be? But if this mediation fails, do I have a better alternative outside of mediation, outside of a mediated case? What are the alternatives? And then you have to compare both. Now, is the client's interest here? The lawyer's fees, don't get me wrong, are very, very important, because you're lawyering because you need money, you're working, you're doing the business of a lawyer to be paid for what you do. But now, part of that big picture is that this person you're representing needs to get what they want out of a dispute. So how do you prepare your clients? How do you prepare your clients? If a matter is referred by the court to the multi-door courthouse, would you take time to have yet another session with your client? You did before you filed your pleadings. Now you want to know from your clients, what really exactly happened? This land that you paid a part for, and the other part remains unpaid, and the land has now been sold for the other person. What did you really require this land for? Was it just an investment you wanted to make in the land so that after the next 10 years, you can get something back? If you are offered, for instance, the price for the land that you paid 5 years ago, in return, if you are to be reimbursed that amount, are you prepared to accept it? Would that be okay for you? Would you accept it and walk away? What actually do you want out of this? All right? So, who would you have in the mediation room? Now we are having a few challenges now. I'll explain that. A matter comes to mediation, and you look at, as a mediator, both parties have a plan, okay? And both plans are saying absolutely different things. Now you want a plan that can explain the divergence, okay, in ownership. You want a single plan. So you get a surveyor. The multi-door courthouse has registered surveyors that we use, and we control the fees that parties have to pay. We also have accountants that we also ensure that they charge a minimal affordable fee for the parties working on the accounts or something. Interestingly, I've had in the last 2 years cases in which, when the surveyor got back with the dispute survey plan, one of the lands in question was nowhere within the vicinity of the disputed land, 3 kilometers away. And I said to the lawyers, why are you going to court blindsided? And for me, irrespective of a professional service being rendered by a lawyer, I think it's a huge error of, I don't know what to call it, of legal representation. You're in court for a land that is nowhere near according to your survey plans. So what we find out now, in many cases, there needs to be intermediate administrative processes taking place. And all that expands the mediation time. Our rules say within 60 days of the appointment of a mediator, the matter should be settled. But when a surveyor gets involved, he needs another 1 month, 2 months. When an accountant gets involved, and in many cases, the homeowners and family members, especially in land matters, they want a voice in the mediation. And many times, some of them are outside the jurisdiction. Some of them are in Port Harcourt, some in Abuja, some of them are even abroad, and they want a voice within the mediation. Now, before I round this up, one thing I learned recently, which is a practice in the United States. Mediations are typically one-day processes. And you have mediations that are running into millions of dollars. One day, it's a one-day process. And I shadowed some of those mediations, and I was asking myself, the level of efficiency that I see in these programs is, if we can even get 1/10 of that level of efficiency, our multi-door courthouses would really be making waves in our nation. Now, what they do, which is what I think we need to experiment in Enugu State, is that there is a lot of interaction between the mediator and counsel to the parties. So the day that they hit the mediation, they say the mediation is the 19th day of February 2024. As parties come into the room, many times they don't worry about opening statements. They just break into caucuses and they hit the ground running. Everything that is needed, there's been adequate discoveries on every front. Survey plans, documentation, letters, all those things that make us adjourn matters. So this person can do this and that person can do that. Everything is already in place when the mediation starts. So if we have that level of cooperation among the legal community, once your matter is referred, you can begin to engage with the mediator, either on phone, online, explain to the mediator, answer questions based on what you have filed, and everybody is prepared. There's nothing outside those deliberations that is further required other than the parties should meet and mediate. If it's something that you lawyers think is doable, can I have a show of hands? Can I have a show of hands if you feel it's doable? You know, Nugu lawyers, you will not fall my hand. Though. The Leonard SAN has put up, will we have your cooperation? Yes. Okay, my lords of the High Court, will we have your cooperation, my lords? We don't have any problems with the judges too. I know. Thank you, my lord. Leonard magistrates. Make una no for my hand. Okay, thank you very much, everybody. Any questions whatsoever? Even if you want to report me here, I am ready to be reported.
This microphone requires a lot of muscle before I can take my voice. Yes, thank you, Setu. You know that we are midwives of the multi-door courthouse. I stand both for myself as a practicing lawyer of Obra Legal and also as a facilitator of Enugu State Enugu State Justice Reform Team, who are collaborating.
And the vice chairman.
And the vice chairman of the Enugu State Multi-Door Courthouse. So I am like in the middle of it. Thank you very much. You're doing a lot of work here, so we're not reporting you for anything. The only thing about is that you have opened only one door in the multi-door courthouse. All the other doors are locked, but we'll talk about it when we get home.
Let me say something, man.
Yes, please.
It's not uncommon. I've explained before. The courts are adjudicating, fine. The multi-door courthouse is providing alternative, which is mediation. The arbitration door. Yes, we've had 3 requests for arbitration. Once we show them our miserly fees, which is absolutely nothing to compare with the fees charged for arbitrations nationwide, the parties say they don't want arbitration again. They want to have a submission agreement to do mediation.
Let me
There's nothing we can do about it.
I am chairman of the Enugu branch of the Nigerian Institute of Chartered Arbitrators. Let us know. We have arbitrators. But we're going to talk a lot more.
Okay.
Because
okay.
we're thinking of also a week for settlement, but this time arbitration, not mediation, but we'll talk about it.
Okay, ma.
Yes, thank you. But that's
you
not
so
why I
much.
stood up anyway. Why I stood up is I'm looking at the second segment which you are handling, that is timings, communications between court, multi-door courthouse, and parties.
Yes.
Now, there's something you raised that will make an order for matters to go to the multi-door courthouse and the parties won't appear. I'm speaking from the experience of a case that I have, actually more than one case, where a court has made an order referring our case to the multi-door courthouse for mediation. And for months, nothing has been done, not because of any fault on the part of the house or the court, but because there has been some break in communication between the court and the multi-door courthouse. And that's why I'm looking at it. Because of a time that ought to be saved in mediation is being expended unnecessarily. So I was trying to, I've been thinking about it and I want to make a suggestion. I don't know how my lords are going to take it, but I'll suggest if my lords and your worships make an order for a matter to go to the multi-door courthouse for mediation, at the same time, that order should bear an adjournment of the case to the multi-door courthouse to a specific date for parties to appear there. One, that takes kind of a timing. So that if it is adjourned today, my lords could say on the 31st, yes, bringing me the case number and parties here, so I'm not talking off cuff. It's E/609 2018, Raymond Chibuoke against Vincent Ezewali and others. It's a case from my office. We've never come because the file has not been moved. So I suggest that my lords should now adjourn the case probably 30th of January 2024 for parties to appear at the multi-door courthouse. And it is in the order. Thereafter, the clerk of court will ensure that that order is enrolled and signed by the judge at least within 7 days maximum. Within 7 days, the order should be drawn up, signed, and the clerk of carry the file with the order and transmit it to the multi-door courthouse. It will be received by your registrar there or the front desk officer there and will be entered in, well, whatever documentation you need to do, but that matter would have gone from the court formally to the multi-door courthouse. And on the adjourned date, the parties will now appear. Once you get the file there, you can now, based on that order, bearing an appearance date, issue hearing notices to the parties for them to appear at the multi-door courthouse on the date already adjourned by the court. In that way, this communication between the court, the multi-door courthouse, and the parties will kickstart the proceedings at the multi-door courthouse within the time frame that it ought to happen. If we coordinate it in that manner, this, my case, is more than a year, almost. How many months? My people are at the back, but several months and we've not appeared.
Courthouse now.
Because you know why? Because the plaintiffs are not willing. But if there is an order with a date for them to appear, they'll have no option. If we now come there by order, by a formal adjournment, by a hearing notice, and a matter registered already, then we can take off. So I am looking at the topic there, timings, communications between court, multi-door courts, and parties, how we can manage the process so that we don't get this kind of stagnation that is happening here. Thank you very much.
Thank you. Thank you so much, ma'am.
Good afternoon. Good afternoon. Thank you very much. Thank you, Mrs. Etuk. I'm starting with her. I stand on all existing protocol. She's my former boss. Please give her a round of applause. Thank you, Mrs. Etuk, for taking the lead on the issues with the court referrals. I stand on all existing protocol. Please, I'd like the slides up if possible. I'm meant to take what really happens during the mediation session itself. So we're going to look at, can you skip to the slide on commencement of mediation? I want to thank the learned Silk for that extremely valuable suggestion. We're taking it to Lagos also. Yes, I think, please give the learned Silk a round of applause, because we do get referrals. We do get referrals from the court. And then we do have a challenge with communicating the referral to the center. And we hear it's a manpower issue. But really, this is new, a completely new suggestion, that the enrollment order should have the date for appearance in the multi-door courthouse. A completely new suggestion. I thank you for that, Leonard Silk. So we're going to look at the mediation process. Mrs. Etuk has talked about what do you do to get it into the multi-door courthouse? And what is really crucial is that when it gets to the multi-door courthouse, what do you do with that case when it gets to the actual commencement of mediation? What is the lawyer or other professional advocate expected to do? The lawyer is expected to negotiate intelligently and secure the best deal for their client. This says that the mediation advocate goes beyond arguing a client's case, but understands the mediation process and is able to use the process to optimize his client's interests. I want us to note that mediation advocates are not only lawyers. A lot of training is going on now for mediation advocates, and we cannot afford for them to take our space. So as lawyers, we need to take the space as mediation advocates so they don't begin to call other people and other professionals to represent them during mediation. Now let's look at the mediation process. Not everyone will know, but it's important to know that mediation has a process. It might look like something that is easy to do, but it does have a process. So let's look at it. What happens during the mediation? The first thing, let's have an overview of what happens during the mediation. You start with an opening. I heard Mrs. Etuk talk about what is being done in the United States, where an opening may not necessarily be important, but this is the format of a mediation session, and your client needs to understand what is about to happen. Many people come to mediation and they wonder, is it this tough? Is it this thorough? It is this thorough. It starts with an opening statement by the mediator, where the mediator lays a foundation. And the foundation is principles that must be kept. Principles such as neutrality, confidentiality, and so on and so forth. That is the mediator's opening statement. And then after the mediator makes an opening statement, he requests or she requests the parties to make their own opening statements. Primarily, that opening statement of the party is about the facts of the case. So your party must be ready to make their opening statement brief and concise. This is the responsibility of the advocate, to inform the parties of what to expect. Then they move on to private meetings after, of course, setting an agenda. So based on the parties' opening statements, the mediator can create an agenda that these are the issues that have been brought before us today. So what do we do with these issues and how do we move forward? So there is an agenda that is created. And then we move into private meetings, where you begin to explore the issues that have been identified at the opening phase. Now, what we just talked about is the fact that you've had a joint meeting and it's called the opening phase. When you get into the exploration phase, what are you doing? You are exploring the issues that have been raised at that joint session. So it's important that the client and the lawyer understand the issues. Now, this exploration can go on for quite a number of times in different rooms. You're going back and forth. They're called private meetings or caucus meetings. And you must prepare your client for this process, because we find out that clients come in and they feel quite tired. Let's just put it. Right, they feel tired with the hope. Why are you sending me back and forth? So what is happening during exploration is that the mediator needs to clarify. The mediator needs to clarify the issues. So a lot of questioning is going to go on. And they'll be asking questions. What happened? Tell me why it happened. And so your client cannot be wondering why you're asking me all those questions, because it is exploration. And then when you're done with exploration and you walk through all the private sessions, and through all this time, you're exploring the past. What happened in the past? You move on to joint negotiation. And in some mediation practices, it's called bargaining or probing. What are you doing? You must realize as counsel what is going on. Bargaining has commenced. The mediator has laid a foundation by exploring the issues. The next thing now is to bargain. So when you begin to hear exchange in value, bargaining has commenced. So you must prepare your client that at that point, and let's remember that you're still in different rooms. Exploration has gone on. The mediator won't tell you, I'm moving on to the bargaining phase. No, you just find that you're switching and bargaining has commenced. You're still in the private meetings. What are you doing? You're beginning to solve the problems. And then you continue until sufficient value has been exchanged back and forth, back and forth. And what do you get? Some measure of an agreement or some stalemate. You might get to a deadlock where you feel you can't move on, or you might get to a point where parties are tired and you need to take an adjournment. But what has happened is that private sessions going back and forth. I've just discussed 3 phases: the opening, the exploration, the bargaining, and then you get to a conclusion where you sign the mediation agreement. Do we understand the mediation process? So that is the mediation process that you have. And when you get into bargaining, you're moving more into the future. And that's why you have the past and future. And of course, after the agreement and closure, you then have the post-mediation and enforcement of the agreement, which Mrs. Etuk will take. Let's go into a bit of discussion. Now look at the sitting arrangement. Where's the mediator? Who can describe him? Who is he? The man with what? At the head of the table, yes? Who is next to him? Who are the 2 people directly next to him? Oh, yes. Thank you so much. But no. No, and that's why we're here. So, while you're in court, the lawyers enter the bar, right? And the parties stay in the gallery. But in mediation, the people directly next to the mediator are who? We must understand that. It is called a party-driven process. And then the next 2 people or next 3 people will be who? Lawyers, advisors. So that is the role of counsel. And you can see from the sitting arrangement, some people come in and they say, I want to sit next to the mediator. No, that's not your place. It is the place of the parties. They sit next to the mediator and they have direct conversations with the mediator. Our role as counsel is a supportive role. So let us look at what kind of supportive role that should be. So we're going to walk through a case scenario. And as we go through the phases that we understand now, the opening, the exploration, the bargaining, and the closure, we will have this case scenario at the back of our minds. And this is a case I mediated, so it's easy for me to talk through it. So claimant versus 3 defendants and 1 party. The claimant is a lawyer. Please, let's pay attention. We're going to start discussion soon, and I'm going around the room and asking questions. Claimant versus 3 defendants and 1 interested party. The claimant is a lawyer, and I must say he's also a military man. And he's also represented by counsel. And he attends with his wife, who is also a lawyer. So you can imagine the situation. On one side, we have a host of lawyers, right? Then you have the first defendant, who is a company, not at the table, not represented. Second defendant, an individual, owner of the first defendant, not present, not represented. Third defendant, present and represented by counsel. And then you have an interested party. And that's the beauty about mediation. Before the court, it might not be as easy to bring in this interested party, but once the parties agree, let's look at the Arbitration and Mediation Act, it's punctuated by as long as the parties agree. If the parties agree that this interested party is important, then the interested party sits in the room. So there's an interested party who is present and represented by counsel. Next slide, please. Are we following? Thank you. Now let's look at the first scenario. The claimant bought 3 plots of land from the first defendant. Do we remember who the first defendant is? It's a company, right? Is the company present? Okay. Bought 3 plots of land from the first defendant for and on behalf of an association. And the transaction was concluded in the year 2014. Upon the successful conclusion of the transaction in 2014, the claimant expressed to the second defendant his desire to buy another 3 plots of land at the same location. This is where the case starts, right? This is just establishing that there was a relationship. So he, at the same location, and the second defendant has come in, who is the owner of the first defendant, requested that the claimant should pay for the 3 plots of land in the sum of 19.5 million by installments within 3 years, commencing from January 2015 to December 2017, which was agreed to be reduced into writing, and a deed of assignment to be executed after the complete payment of the said sum of 19.5. I'm running through it, you can read with me, please. So in essence, the claimant has got an agreement that he should pay 19.5. What then happens? He paid an initial deposit of 3.5, following which that individual, the second defendant, stops answering his calls. And all efforts to meet him physically or balance the sum of 16 million became impossible, which prompted the claimant to petition the first and second defendant at the Nigerian Police Force. Next slide. The claimant subsequently received an email from the second defendant stating that the first defendant no longer operates in Nigeria and the second defendant has relocated to India. This prompted the claimant to revert to the 3 plots of land left behind by the first and second defendant. So he went there. And what did he find? That the third defendant was occupying the land in dispute. The third defendant apparently bought the property in 2012 from the first and second defendants and made full payment in respect thereof, executed a written agreement with the first and second defendants, and has obtained a governor's consent. Furthermore, he has sold the property to the interested party. Are we following, please? The third defendant did not know the claimant, neither was she aware of his claims and the issue with the first and second defendant until 2018. When the interested party that purchased the land from her began development of the property, and that's when he showed up. Thank you. That's when the claimant showed up. Now they've been referred to court, referred by the court for mediation. So we're going to walk through the mediation process. What happens during the first joint session? Introductions, signing of confidentiality agreement, opening statement. I'm sure we understand this. What is your role at that joint session? Supportive. Read and approve agreements. Agreements are being counsel. Party's opening statement where the information is incomplete. So the party makes an opening statement where the information is incomplete. You contribute. You don't rehash. You contribute and say, oh, my client has left out 1, 2, 3, and that makes the process faster. Let's take some questions. We're on the joint session. During the joint session, the claimant, your client, and I'm coming to us now, your client says to the third defendant, you're a fraudulent woman. You knew I had purchased the property, but you went behind my back to buy the property. I will deal with you. What will you do as a mediation advocate? Remember, you are counsel to who? Who are you counsel to now? Are we following? Who are you counsel to in this circumstance? The claimant, right? You are counsel to the claimant. And this is what has been said to by who? Who says, who makes a statement? Good. Your client makes a statement about who? So I'm coming to counsel. What are you going to do as a mediation advocate? This is a joint session. What do you do?
As a mediation counsel, I would advise that in mediation we don't be judgmental, because that's taking control is sufficient because everything has taken stand already. You are fraudulent. That if you don't have the mind from that area, nothing again will be the process.
So in doing this, who are you speaking to now? Your client in this joint session?
So if my client, if my client has said a problem, I was not my client. No, it's not what to do.
How would you do it? Give us real life. What would you do?
Yes, what I will do is to advise openly there and caution and apologize That person is not violent. Our progress to that person. In the focus meeting there, tell them, so that the will come down. If not, that man may not participate in the election again.
Please, I want to hear another view from the back.
Okay, at that point, I think as a mediation advocate, I'll caution my client immediately by letting him or her know that you are not supposed to use fraudulent languages and
I was
you're not
going
supposed to use
that.
exactly
Okay.
harsh
Yes.
languages
Yes.
in mediation session.
Okay,
Thank
so
you.
remember, please give them a round of applause. But I want to add something to this. Do you have a different view? Same view? Same view, sir. Okay, so we'll come back on another one. Now, it's important. You remember where you're seated. Where are you seated? You're beside your client. So what do you think you should do first? This is emotional intelligence. You started the mediation room.
Yes, taking into account the psychology of practice, you have to, if you haven't done that before entering the mediation process, you will not do it. But as mediation counsel, you have the responsibility to explain to your client how to conduct themselves, the way, the type of language that is allowed and is not allowed. But if there happens to be such an outburst, which can happen for any reason, you whisper to your client, calm him down first, caution him, and tell him that you will apologize on his behalf to the whole house, because that's not the language.
Thank you very much, Leonard Silk. That is exceedingly important because you can destroy the entire mediation process by not talking to your client first. Remember who you're representing. So while the other two speakers are correct, that won't be the first thing to do. This will be the first thing to do. You must whisper to your client first. So let's go to the next one. Okay, so now the next scenario. This is exploration. I had one on that slide, but let's keep along because we want to have enough time to discuss all of it. So this is the mediation process. What happens during exploration? Can anyone tell me, and that's enough for this slide. What happens during exploration and where does it take place? As counsel, I'm coming to the back. Can I hear from you, madam? At the back. Yes, please. What happens during the exploration?
I think we will try to discover the issues at hand. Exploring the issues at hand.
What's the primary tool of the mediator at that point?
Like ask the question.
Great. Give her a round of applause. She's listening, she's following. Now that is very key. Your mediator is going to keep on asking questions. So what is the role of the advocate? What is the role? I'm sure many of us have been in mediation sessions. What should we be doing when the mediator is asking questions in a private meeting? Now we're in a private meeting. What should you be doing? We don't have so much time. You want to speak this time? Not this one. Okay.
For all intents and purposes, the advocate should keep quiet and allow the party to express and answer those questions. Except if there is any time that intervention is needed, he can now whisper to guide the client.
Give him a round of applause, that's fine. You can whisper to guide and you can talk openly because the party might be stuck. Next slide, please. Remember, we're running through this. We've done the joint session where you have the opening. We've just done exploration. We have an idea of what goes on and what the counsel should be doing. Now we're going into bargaining. What is bargaining really? Is exchange of value. Exchange of value. What's the role of the advocate? Change the pace, increase the momentum, support the mediator in maintaining and growing rapport, coach parties to create value and more value. We'll take one scenario. The claimant, so let's leave the claimant this time. The third says that she will not pay any money to the claimant and she has done nothing wrong. As counsel to the third defendant, what would you do? You are counsel to third defendant now. Do we remember who the third defendant is? We remember? Great. So I'm coming to the back. As counsel to the third defendant, what are you going to do? We don't have so much time. We're going to begin to round up. Counsel on this side. Yes, sir. Please answer the question. Our classes are always interactive. Yes. At the back. With a collar. You're looking back, sir. It's you, sir. So, as counsel to the third defendant says she's not paying any money because she hasn't done anything wrong. What are you going to do about it? We're in private meeting with the mediator and with your client.
Well, what I will do is to try to make the third defendant know that the emphasis in the mediation session is to ensure that no person's interest is overlooked, so that she has to give something in order to get what she needs.
Really? Okay, give him a round of applause, like halfway. Okay, thank you for the attempt. Now, does somebody else, that's obviously not correct. Can somebody else make an attempt, please? Do we remember who the third defendant is? Do we remember? Do we remember? You don't. The third defendant.
The third defendant is the person who originally bought in 2012 and had sold to the interested party.
And has title.
And has title and obtained consent of the governor.
Yes, and has sold now to the interested party. Great, we're on the same page now. That is the third defendant. She's saying she's not paying one couple because she didn't do anything wrong. Another view, please. What are you going to do as a counsel? This is your role as a mediation advocate. You are in mediation right now. What are you going to do? I need another counsel to answer. At the back. Yes, please. Yes.
I think first of all, the issue of negotiation it's an issue of sacrifice. What to the client that has not to at least have a shift to
I see.
The process.
What's the third defendant shifting? Why is she shifting? I want to get your view because you're saying there must be a shift. And that's the impression was have that when you come to mediation, we must shift. And I get so many calls that why is the mediator insisting that we shift? What are we shifting on? So I'd like to get your view on why that third defendant must shift.
Insofar as to me, well, that is an issue of mediation. It's never an umbrella or platform for you to prove right or prove wrong. If you have seen that the party still has an interest, even though it's an unknown to you, but you have seen what is on ground, you can at least, in order to bring peace,
okay,
make a shift.
Thank you very much, sir. This is why we're here today. I'm going to come to, I believe I have your honest magistrates here. What do you think should happen with the third defendant after she's made that comment? What's your opinion? It's an interactive class, so we need to speak, right? So I'm going to point right at the back, light-skinned. Please give her the microphone. We want to hear from you. Yes, she's turning to the, that's her. Yes, yes, give it to her. Thank you very much, Your Honor. Please answer so we can move on. We must engage because we will be in these sessions and these are the decisions we take on the go.
Sorry, please, can I get a question again?
I see. Okay, the question. Can we show the slides again? Just know that if you come to a mediation advocacy class, it's interactive and you must listen. Can we get the slides again? Slide, please. You can answer the question. Okay. The third defendant. You understand who the third defendant is, Your Honor? Hello? Hello?
Yeah, I can hear you.
You understand who the third defendant is?
Yes.
Great. The third defendant says that she will not pay any money to the claimant and she has done nothing wrong. As counsel to the third defendant, what would you do?
As a counsel to the third defendant, I will listen to, what I will do first is to listen to the mediator, then listen to the counsel to the claimant. So whatever they are,
You're in a private meeting, you're in a caucus.
Yes.
It's just you, the mediator, and the third defendant.
That's what I'm saying. I'll listen to them. Whatever they agree on, then maybe from there I'll take it up.
Wow.
Yes.
Wow. Please, can we have the mic here? I'm not going to answer this. No, we are counsel in mediation. We must have an idea. Mic here, please.
My view being straight forward and in the interest of my client. Because my client, before we came to mediation, we must have had discussion, and I came to the understanding of what may be her liability, if any.
Yes.
In this case, looking at it from top to bottom, she does not have, my client as a thought, does not have liability. Remember that she acquired and got all the title documents and had transferred his interest to a third party.
Yes.
Then the issue will now be between the claimant and the third person.
Please give him a round of applause, please. Thank you. That's enough. I'm done with this slide. So that is it. You cannot say, counsel, you do not know the answer to that question. Well, that's why we're here anyway. And that's why when we go to mediation, they ask us, what is this mediation about? What are you trying to do? There was a case I handled, and I think that was a turning point for me, where counsel looked at me and said, why are you forcing me to settle? My client gave this amount of money to his friend. I'm talking of another case. And this was a turning point in my career. My client gave about $8,000 to his friend. And then the friend says, years down the line, that he's sick and cannot pay the $8,000 anymore. What does he say now? That I can give you $4,000. On what premise? That he is sick. And I'm saying, can we find a way out? Please, can you tell me what is the way out? What is the way out? And as I continued to say, like 3 others or 4 others have said here, mediation is about peace. Does peace mean there's no value? Let's not make a mess of this profession. Mediation is a profession, and it must be done right. That third defendant has no liability. And in fact, the interested party, does the person have a liability? But can there be a stretch for the interested party? Can there be a negotiating space for that interested party? Yes, I'm sure we all agree. Why? Thank you, my Lord. Thank you. Please give me a round of applause. That is when you need peace. Why? He wants peaceful possession of that property. Remember that the claimant is counsel, his wife is counsel, he has counsel, he's a military man. So the place will be fighting for years. But that interested party, that is who you can point out as a third defendant and say, and this is the value we're talking about in bargaining. You can then say, can we have a conversation between third defendants, your client who is who? Claimant. And who? Thank you. And you have a conversation. That is where you will find value. Let's go to the next slide, please, because we don't have all that time. Next slide, please. Walk through the opening, the exploration. We look at what bargaining can be. You can have these conversations. I hope the slides will be shared. Have these conversations later and say, what would I do in this situation? Next slide, please. Now you get to a deadlock. The interested party says, I'm a wealthy man with lots of property, and I can pay for the property twice. But I don't want to be taken for a ride. And at the same time, I want peaceful action. I can only offer 2.5 million to the claimant. I didn't read it. In the previous slide, the claimant had asked for 5 million. As counsel to the interested party, how can you facilitate movement, knowing that your role is to get the best deal for your client while taking into consideration your client's interests? You are counsel now to the interested party, and we're going to wrap up shortly. You are counsel to the interested party. He says, I can only give 2.5 million as against 5 million.
Do you see his prior statement? I am a wealthy man with lots of property and I can pay for this property twice, right? But I don't want to be taken for a ride. And at the same time, I want peaceful possession. This is the interested party talking to you as counsel. Counsel to interested party. What would you say when he says, I can only give 2.5 million? Meanwhile, the claimant is asking for 5 million. Contributions, please. If you don't talk, we'll call you anyway. Contributions? You are counsel to the interested party, right? Yes. Right? Oh, thank you. Thank you for volunteering. Let's hear from you.
Yes, since my client is aware of the need for peaceful possession, and I know that he can afford it from his statement, I will encourage him, holding on to his interest, to go further. Yes.
Okay. He's on the right path. But you need to be careful with your clients too, so they don't see you as shifting to the other side. But what the essence of this conversation is that you are creating value for your client, and you can let him know, not just because he can afford it. That's a dangerous part to tread on. Not just because he can afford it, but because it will give him more value. You heard Nba-Slp when he was speaking, talk about creating value. That's what builds them. So the value is, if we complete today, you can enjoy peaceful possession. If you conclude today, this case will not be sent back to court for trial. Is it possible in view of these needs of yours that you can consider some added sum? You must negotiate on value. If you negotiate without anything in your hands, you look incompetent. You look incompetent. Let's go to the next slide, please. So we have walked through, that's a deadlock. So you see that the role of the advocate is a very crucial role. It's a very crucial role. You don't sit directly beside the mediator, but you're doing an awful lot of work. So that's how you can break a deadlock, by thinking through the value creation. Next slide, please. Further roles. Of course, 2 more roles. You are a negotiator, you are a strategist. That's your role as a mediation advocate. You're also a supporter and a coach. You manage your client's emotions, help the client relax, and approach negotiations constructively. Engender trust and confidence in the process. Excuse me, came to Enugu yesterday. The weather hit my throat. I'm not joking. And I've been drinking all sorts and taking lozenges and a lot of water, thank you. So that's why you're hearing that in my voice. So engender trust and confidence in the process and mediator. Focus on clients' real interest and not legal positions. There's something I wanted to say, yes. Under your role as negotiator and strategist, it's so key that you use the legal case as a term of reference. We're not saying do away with legal provisions. That's what it is. There's precedents, there are court cases on that issue. But you use it as a term of reference and not as a bargaining position. So you can refer to it essentially as a bargaining chip. Next slide. So you've done all of this. You're now down to the settlement agreement. The key things to note. So we wrap up. Is it workable? What is the purpose of the settlement agreement? Settlement agreement. The draft agreement with the mediator on behalf of your client. You should write up the agreement. I've just said that. What are the contents of the agreement? Is it enforceable? I should include a default clause. Is it specific? Is it measurable? Is it achievable? Is it realistic? Is it time-bound? These are the considerations you must have in drafting your terms of settlement. I'll take one more. Next slide, please. So let's look at just this paragraph. You can read up the remaining. This was part of the settlement terms. So the current occupier shall pay the sum of 3.250 million to the claimant. This was the agreement, and this is life. Of course, we've changed the names and everything. To ensure peace is restored and to give the current occupier peaceful possession of the 3 plots of land, which is which measured approximately this size and situated in this place with a coordinate of this and this. We're very specific
in our drafting. And this is the role of, before we got to this draft, it took us about 2 weeks. There was a process in drafting these terms of settlement. So conclusively, that is an outline, as much as we can do within the time given, of what it means to go through a mediation process as a mediation advocate. Thank you very much.
Well, I agree with me that this workshop is rich, and you're sitting down here listening is worth it. I know that most of us are whispering that you have your questions. Please, I want you to write it down. We're going to take all the questions after we must have finished the last session. And but now that I want to make some comments concerning what we have been taught. I know actually that naturally we would desire that the dispute be settled amicably. But there are some issues that come to play when lawyers are involved, and we must take care of that aspect of the fees. I understand very clearly that some of the actions we have taken when I was the chairman of the bar, and some of the discussions we made, one of the things that keep occurring is the fear of being paid. And I understand that if you don't take that fear, address it directly, lawyers will always be a problem to dispute settlement. And my point I want to make here, just that point, we'll make the other one after the last session, is that we lawyers, there are many ways we do our charges, but the advice in the bottom line is that if you package yourself very well, and the client knows that this person must add value, just like you do in other litigation matters, there's no way they will not pay. In the remuneration order, there is provision for consultation, which was not similar to popular, where a lawyer is consulted and without even filing any process or going to court, you pay maybe the minimum that is available according to your age. There is 500,000, there is 200,000, there is 1 million, and all that. So when you understand that very well, and a client is advised clearly about ADR, I think that fee issue will be taken care of. It's not about to say to thank you.
Thank you. Thank you, Mrs. Cole. Now we have a settlement agreement in hand. And what does the lawyer do next when you have a settlement agreement? There's an endorsement process for the settlement agreement. You get a date and the parties sign the agreement. Now, for the multi-door courthouses, there is, apart from the claimant and the respondent, or the claimant and the defendant, there's also provision for counsel to the parties to endorse the settlement agreement. So at the settlement agreement signing, now we have a win-win. Okay, we don't have a win-lose situation as you would have at the end of the litigation. We have a win-win. So parties sign after the counsel to the parties, of course, have read and ensured that the terms of settlement represent your client's interest. So the endorsement is now effected. Now we have had situations where counsel have not attended mediation sessions. Parties have arrived at a settlement and counsel refused to sign. And in many cases, I believe this has something or the other to do with outstanding fees to counsel. Now, my suggestion, which is what the mediators have discussed, if counsel has fee issues, mediation is a confidential process. If lawyers have fee issues, there's a fear that if we conclude this mediation, I will not get paid my fees, my negotiated fees with the parties. Those are matters that can be brought up and mediated upon. Now it's called an intermediation. The mediator can mediate between you, the lawyer, and your client. It is very, very, very much in place. It can be done, and it's being done. So that at the end of the day, the lawyer is not shortchanged. So we have had situations where we've had to, because the lawyers refuse to endorse the terms of settlement, we have had to carry the terms of settlement with the parties' endorsement alone to the courts. And we have given the judges or the magistrates the responsibility of doing the intermediation. So terms of settlement are signed. The multi-door courthouse has possession of that. All we do is that we carry the terms of settlement to the court registry. Now, before now, we used to take the terms of settlement for court-referred matters to the court registrars. And we had numerous problems arising following that. So the process now is that terms of settlement goes to the court registrar. The multi-door courthouse notifies, is that the same thing in Lagos still? Goes to the court registrar. Okay. So we notify the parties and their counsel. Your terms of settlement have reached the court registrar. Please go there and follow up with the process. Now, the expectation is particularly for the applicant to go to the court registry, ask for the terms of settlement. You can identify it by the MDC name or the suit number or the party's name, pay a filing fees, and file the terms of settlement. Now, for working matters, the same process happens, but you pay the filing fees, and when that is done, a suit number of the Enugu State High Court or Magistrate Court is given to that terms of settlement. And then the terms of settlement are, if it's a court-referred matter, it's now taken back to the referral court. If it's a working matter, it goes either to the ADR judge, as it gets assigned either to the ADR judge or to the ADR magistrate. So that is simply the process. Now, what the Enugu State Multi-Door Courthouse is doing now, we have opened a unit for the endorsement of terms of settlement. Because we find out that when matters come to the multi-door courthouse and they are working matters, many of them, the parties don't have counsel. So when the terms of settlement are sent to the registry, they are at a loss as at what to do. And for many of them, they really cannot afford to engage a lawyer. Now we took steps to appoint lawyers who can help these parties, but they too were charging fees which the parties considered exorbitant. Now we are going to have, for walk-in matters, a unit where internally we are going to facilitate the adoption of terms of settlement on behalf of the parties. So when terms of settlement have been adopted as consent judgment of the court, now, if the parties do not comply with those terms, of course, it's in the forte of you lawyers for the enforcement. You know what to do next to get the terms of settlement or the judgment of court enforced. So that basically is the procedure. And the procedure is very, very simple. Now, another thing we encourage is as it used to be, you carry terms of settlement to the court, even for court-referred matters, and nobody goes to the court registry, even when you've been notified that your terms of settlement are in the court. There's been no follow-up, active follow-up by the lawyers. So that needs to be looked into. If you're an applicant in a case or a respondent in a case, and you're notified by the multi-door courthouse, your case is now, your terms of settlement are now at the registry. We expect that there will be some follow-up, and that terms of settlement does not have to lie. Sometimes the court even requests, because once we do the terms to the registry, a letter goes straight to the court, a concluding letter saying this matter has been finished, terms of settlement have been signed and submitted at the registry. And then we also attach a copy of the terms to the court. So after a while, the court is now asking, what is happening to this case? Because it's not being followed up by the lawyers. So I think lawyers, please give due attention to your terms of settlement, get them endorsed by the court and adopted as consent judgment of the courts. Now there are a few, I never got to get slides. Well, there are a few things that I like to mention, which are ADR related critical issues, I call them. The use of ADR clauses in your contracts is critical. Now, once there's a buy-in of the legal community and we say these are sample terms, these are sample clauses, ADR clauses that you can inject into your contracts, it makes life easy for everybody because the contracting parties know right away that if there's a dispute, first thing we do is to negotiate within a time frame. If negotiations fails, we are going to mediation, which means we are going to employ the use of a neutral third party to help us broker a settlement. Now, if that fails, we are going to take a third step, which is either arbitration or litigation. Now, as a matter of policy, I understand that the Enugu state government is adopting an ADR, an ADR, I don't know, should I say an ADR clause system across all of its business transactions, contracts, etc. And it goes negotiation, mediation, and litigation. So it's something I think the legal community needs to look at. Now, a hybrid process mentality is what every lawyer should have. When you file your matter in court, also have an expectation that there's a possibility of your matter being referred to ADR so that it doesn't take you by surprise. Oh, this court referred my matter to ADR. Oh, I made all these protests and the courts did not listen. Because you now have hybrid processes. You can mediate your matter, arbitrate it. You can arbitrate it and mediate it. Now, arbitration and mediation can actually run concurrently in the life of a dispute. So have an expectation as lawyers that your matters might be exposed to a hybrid environment. Confidentiality is key in mediation. When parties come, we always make sure that they sign a confidentiality agreement. You do not go back to court at the end of the arbitration, of the mediation, and tell the court everything that has transpired and how the process went. Because this very act, this breach of confidentiality, it affects the mindset of a judge or a magistrate. So if your matter does not fly in mediation, go back to court with an open mind and start your trial without abusing the mind of the judge or the magistrate as to what happened in mediation and who was the recalcitrant person and on whose account the mediation failed and all such things. Lack of good faith. Many a time lawyers come to mediation and they are asking and instigating, or should I say, ensuring that the mediation, they want the mediation to have 5 sessions, 6 sessions. They have absolutely no interest in engaging in the mediation with a good faith disposition. They are not interested in a settlement. They just want to buy time. And that is wrong. If a matter is not making progress in mediation, we are not going to turn the multi-door court houses into regular traditional courts, where you can come and let your matter just lie there and relax for year after year. If a matter comes to the multi-door courthouse, our sole responsibility is to provide adequate service, mediation service. We give you the full works. We give it fast. We follow the timelines. And if we have done our best, sometimes when matters fail, they are referred to me. So I intervene. I take the last lap and just see whether the mediator has done their optimum best in the attempt to resolve the matter. Many times I succeed. Sometimes I fail. But the important thing is that the matter hits the multi-door courthouse. We do our own thing. If we settle, great. We send the terms of settlement back to the court. If we don't settle, great. We send back the case to the court so that trial commences immediately. So when lawyers start to do, they are going back and forth, it really is not in the interest of the clients. And sometimes lawyers misrepresent facts, absolutely misrepresent facts. The whole essence of a mediation is that the mediation works on a bedrock of truth, openness, empathy. The mediator wants to know what really is true and real about this case. What is it that is driving the parties? Are the parties able to get what they really want from this mediation? But when lawyers come and misrepresent facts, and some lawyers insist that the facts that they have on their pleadings must be the facts that must be used in this mediation, that too is wrong because it puts a cloud over the mediation. Now I'll ask one question, 2 questions. If a mediation fails, is it a waste of time and resources? Is there any gain from a failed mediation? That's my question to the lawyers. Please, can you give the mic to Chief Mrs. Sophia S.A.? No, ma, I want you to answer this one first. If a mediation fails, is it a waste of time and resources?
From a general point of view, no experience is ever a waste in life. If parties have tried mediation and it fails, it cannot be a waste of time and resources. We would at least have been able to explore many issues there, known what the other party is expecting, stand our own case better as far as the clients are concerned, and even the lawyers also, and many other advantages that would have come from it. So it's never a waste. If you have to go back to court, you'll be going back to court at least knowing, well, I could have made this concession. I now am more aware of facts like what you discovered about a land being 3 kilometers away from where it is pleaded to be. You know that now. So as a lawyer, you will be able to tell your client, look, this litigation may not be worth your while, possibly. Or now I think this is the path that we can take. So yeah, I don't think it's ever a waste.
Thank
Maybe
you.
other advantages that I have not thought of right now. I'm sure other people will have other ideas.
Thank you so much. Anybody else? Okay.
It can never be a waste. Trying to settle peacefully, trying to explore other options. Like Leonard Sand rightly pointed out, council parties would learn certain things. And at the end of the day, when they go to court, go back to court, they'll know that they tried out all options.
Yeah, I'm going to answer.
So trying to settle peacefully, trying the mediators can never, ever be a waste. Thank you very much.
Thank you so much.
Thank you, my director. All protocols duly observed. I agree that going to mediation can never be a waste. Like I tell people in court, it will give the parties that opportunity to let out their emotions, their frustrations, an opportunity that they would never have in a regular court. Even if eventually they do not settle, they would have heard each other's frustrations, each other's, perspective on that dispute, which ordinarily they may not have the opportunity to let out. We know that ultimately what everybody wants is a settlement, but if it doesn't work, well, they would have had that experience. Thank you very much.
Thank you.
Let me just use this opportunity. The suggestion by Leonard Silk about, when you're making the order, the referral order, to put an adjournment date for the multi-door courthouse. I was just wondering how that pans out. Considering that already making a referral order, some people may not want to respond to a regular order. It's not because you haven't given them a date, but some people know that mediation is supposed to be a voluntary process. And so, even if you gave a date, the person that doesn't want to go may still not go. I think that once the court has made a referral order, it is for the multi-door courthouse to invite the parties. Also, just like when the multi-door courthouse has prepared the agreement and everything, and it's to transmit to the court so that the court can enter. And so I'm happy that you said you have set up a unit, or you will set up a unit that will ensure that that process is facilitated. I hope that unit will also undertake this. Thank you very much.
Thank you so much, my lord. Now I am going to sit down. My time is up, but I'm going to ask a question to my own son. Now the question is a question of contingency fees, which says that the lawyer is going to be paid based on what the lawyer realizes at the end of the litigation or the mediation. Now, within a mediation context, how is, because if you have agreed on, what within a mediation context, it gives the lawyer a certain expectation that is in contrast or is pushing against the grain of a settlement that says, okay, let's beat this thing down from 10 million to 5 million. The client is willing to do 5, 6 million, something in that range. And there's a lawyer in the room that has an interest, a vested interest in the mediation. How do you think his fees, how do you think that scenario should be navigated?
All right, thank you very much. I think it was becoming practice to find parties drafted agreements and those in the agreements or in the pleadings insert a certain amount of fee or apart from inserting the fee, they also prepare pleadings and agree with the litigant that there will be a certain amount of the fee or the percentage of amount from the litigation. Now, I want to state that this is maintenance. This is not applicable in Nigeria. It is, we have two aspects of ethical conduct. One is charity and the other one is maintenance. When you pick up a proof, you take up a proof for the skill you provide. You do not know or the outcome of a process. You submit your course of action to the court, you submit your proposal to the court as an impartial applicant. These are the principles and also it. The same, when you go to mediation, you submit the mediation is a voluntary process which is triggered by parties. And for the skill you provide, I'm sure that we find the illustration very helpful. The steps of arbitration from the opening statements, when we have the caucus meeting, when you divide the parties into caucus, the exploration, and all the role that to be played by the lawyer. At the end, you cannot say that the percentage will only come to you because the matter may not be settled by mediation. It may go back to court. And that means that you have failed. In fact, some of the litigants on litigants think that the mediators are judges. So that's if you work with the mediators, they will give you judgment. And such employment that a percentage will be paid already fuels that type of thinking that somehow the mediators are judges and will give you judgment. So I think it's important to realize that that policy or that law, that regulation, I'll call it, applies in the United States where non-lawyers can invest in firms. So it's like an equity investments, they can invest, and at the end of each month, they get a return on investments. The same happens when you find lawyers who can maintain cases with their money, and at the end, you take a percentage of what you get out of that case. But it is not applicable in Nigeria because we operate in a fiscal system, not a jury system.
Thank you so much for that answer. I've seen this scenario in arbitration proceedings, both in terms of how the arbitrator's fees are determined and how counsel fees are determined. That is to say, what I've seen happen is at the beginning of the proceedings, if you take arbitrator's fees, for instance, the arbitrator fees is usually contingent on the amount claimed. So if you're claiming 50 million naira, then the arbitrator's fees will be a percentage of that. Now, what I typically do if I'm an arbitrator or if I'm on an arbitral tribunal is to say the parties are not precluded from settling your disputes. And if you settle at the stage of filing your claim, then the arbitrators will only be entitled to X% of that total fee. If it is after pleadings have been settled, but before hearing, X%. And it scales up as you go along. For counsel, I haven't seen it operate as much. It's not a policy that I typically do, particularly when it comes to the ADR fields, because again, as my learned brother has said, we do not want to put ourselves in a position where we are conflicted. That is to say, our interest in securing a fee is now placed over and above the client's interest to settle. So I typically don't like basing my fee on to say we will recover this amount for you. I would rather say if we achieve this outcome rather than a specific amount, then we have a success fee. So that is to say, if I can settle it for you by this stage, then I have a success fee, not if I can get you this amount out. So I like to base it on outcomes other than a monetary value, if that makes sense. But it would be, there is much room for further discussion. Well, my brother will do the vote of thanks, but I just want to gauge your interest. Did you derive value from this workshop? You did. Thank you. Thank you. If you did, I won't ask you to pay us anything. You remember I talked about if I give you value, I won't ask you to pay anything. What I will ask you to do, most respectfully, is that you consider joining the Nigerian Bar Association section on legal practice. Because this is what we do. We exchange views frankly on issues that affect you as legal practitioners and the interface between the legal practitioners and the judiciary. So if you actually found it to be valuable, then I guarantee you that other committees of the SLP, you will find their workshops also valuable. So please take a moment, visit nba-slp.org and consider being a member of this practice. And I'll give you another reason why. Based on these discussions we have had today, and I've gotten the permission of Chief Mrs. Afia to put this across, we have decided to do three things. Firstly, we have decided as SLP to have a conversation with the legal profession here in Enugu and with the judiciary with a view to enhancing, or if I can put it, to drafting practice directions that are fit for purpose. Fit for purpose in the sense that they capture the concern that Chief Mrs. Afia highlighted, and also take into consideration the other concern that my Lord highlighted, that is to say, who should have the primary responsibility of driving this process. I think if we are able to have that discussion, we can craft something that will serve as a model for the other 22 or 20